Good morning, everybody, and welcome to our live stream today. It's great to have you with us, and I just want to introduce myself. My name is Jeff Fowler. I'm the Vice President here at Apartment Owners Association of California, and just want to give you a quick introduction of our company here. It's the largest individually organized group of apartment owners in the state, and our goal is to help you make and or keep more money than ever before, and also to make that process easier and more enjoyable. And so today we believe that we have something that will help you get there. One of the big thoughts this morning that I had was what you don't know may cost you a fortune. And we don't know what we don't know, but what here at AOA, we can't predict the future, but we can give you good information that will help you manage your property. And so that's what we're here for. I want to highlight the magazine that we have. You see this here, and look at that. There's Dennis Block, and he has an article every month in the LA magazines, and up north we have a different attorney that writes, and in San Diego we also have another attorney that writes, and so locally relevant material for you there. And so please, this is one of the things you get when you join. You get this every single month, and it also does have the vendors and money saver coupons there on the back. And anyway, it's a great way to stay informed so that you have the information that you need so you don't lose a fortune. And also one other thing that's happening right now, just saw a report from TransUnion, and fraud is up from 10% last year to 15% this year. So what that means is that you have people that are falsifying all kinds of their bank statements and things like that. So you really want to make sure that you are screening your tenants and double checking all of that documentation. We do that here, if you didn't know, and you can sign up for that and get on the website. There's an online form that you fill out. There's a identity verification that happens within seconds, and then the site inspection. Site inspection may not be easy, it may take a little time, but after you do that, you have great prices and a tested great service for you. So I wanted to highlight that. Also, one other thing I wanted to highlight is that we do have a debt reporting service. And what's great about it is that we get your debt are reported to the 3 credit bureaus, and that will hold them accountable. And through that, at least the next landlord that gets that tenant will know not to take the tenant. And hopefully it will also put a little fire under them to actually get them to pay. And then it does turn to collections after 120 days. So those are 3 different services. You can find those on the website or call in and ask about it. And by chance, were you here for our last live stream? So you may have missed something really important. Before you get a bid on having your roof redone, I want you to watch this video, and it also could help you save money. I was shocked, but what I found out is that there's a process when you have a roof installed, and if the manufacturer doesn't come out and see that, then your roof, warranty is void. And so 95% of warranties are void. So if you go back and look at that, you can see how to do that yourself. And anyway, so that was Paul Reyes. Really engaging guy, and so he just brought such a great one, so I want you to look at that. As well, on December 3rd, he's going to be speaking again, and it's going to be about SB 721 and with building inspections. And so again, I think Paul will bring a really a lot of information that will help you, keep you from making mistakes. It'll help you save money and get things done the right way. So just wanted to mention those things today. Our speaker, he is going to present about landlord-tenant law, the different things that are going on right now. There will be a question and answer at the end. So hold your questions, because you may get your question answered just during his presentation. And then at the end, go ahead and ask questions, and we'll take time to answer those. If you are on the AOAUSA.com website, you'll see that there's a help button there where you can just enter in a question into that chat, and then they'll get that to me, and I will moderate and get those questions asked, as well as on YouTube and Facebook. You can do the same. Just put that in the chat, and then hopefully we'll get to that question for you. And for all these things, we don't want you to miss out. And these live streams, all you have to do is subscribe to AOAUSA.com, and then go ahead and hit that notification bell, and it will let you know whenever you have to, whenever we're going to go live, and then that way you have a little notification and you can make sure you catch it. And if you like the content today, go ahead and give it a like. And this will be information that you'll want to share with your friends that also do own buildings as well. And yes, great. So I'll get to introducing the speaker today. So he's been in business for over 44 years. He's done over 200, his firm has done over 200,000 evictions. I think we'd have to have an audit. He may have done more evictions than anyone in the whole state. Just incredible experience, great staff, and just incredible work ethic. And he is effective. So if you have a problem tenant, he's definitely one of the guys that you would want to go to. And he also founded his company, and yeah, so just an incredible guy. He's evicted all kinds of things, and including yachts from harbors or whatever, docks, and all kinds of stuff. So incredible guy. He's been with AOA advertising and writing a column for us, and just helping in so many ways. Our forms, he reviews our forms so that we make sure that everything is up to date and right on point. So we're really thankful for our speaker today. It's my pleasure to introduce him, Dennis Block. Thanks.
Thank you, Jeff, and welcome everybody. Happy to be here again. We have so many developments that are occurring in our state. Most people thought that I was going to be speaking about the new tenant laws, but I'm changing it. What I'm going to be talking about today is I'm going to talk about the governmental assault on income property owners, because that's what we have. It's a governmental assault on income property owners. And yes, it's also known as the Tenant Relief Act, AB 3088. But make no doubt about it, it's a war against income property owners, and that's what we're facing right now. Unlike any other industry, the government has placed financial responsibility of supporting of tenants on the shoulders of landlords. That's what they've done. No other industry is forced to individually support another segment of our society, except for income property owners. Drug manufacturers, they're not forced to give out their drugs for free. Hospitals are not required to perform services for free. Markets, which has food, are not required to give out their food to people in need. Only landlords, which are designated by our governmental officials, specifically in AB 3088, is forced to give away their services. And it makes no difference that no rent is coming in. Landlords are still required to pay property taxes, their mortgage payments. They have to keep the upkeep of the building with repairs. In fact, if they don't, they could be cited by a local municipality, and even with criminal charges. They also have to pay the utilities for the building, the water and sewage charges. And yet, it's sanctioned by our government, by the state of California under AB 3088 that they have to, what they say is, have their rent deferred. Rent deferred. Well, the truth of the matter is, even though the statute specifically states that rent is deferred, it is truly not. What it really is, it's rent forgiven. There are losses to property owners that will be staggering in the billions of dollars in the state of California based on the fact that these rents will never be seen by landlords. This, quote, deferred rent really is a hoax played by our politicians that the rent will sometime, somehow be paid down the road. That is not the case. What we're going to have is rent forgiveness where literally landlords will be giving up billions of dollars. I have seen in my practice so many landlords that are willing to tell the tenant, look, just get out and I'll waive all the rent. Thousands and thousands of dollars, but the landlord knows that they have little avenues of getting the particular tenant out and would rather just give up all the money. But then again, many tenants say, why should I? Why should I get out now? I can continue to take from you with no thought that these payments will ever be made. But that's what we have. And I have client after client telling me that this person in a first apartment owes me $15,000. That owes me $18,000. This tenant owes me $20,000. These rents will never be recouped by the landlord, and this is governmental sanctions of theft of rent from landlords. Now, the politicians in this law tell us that there is the possibility, and you have the right to file a civil lawsuit, which I'm going to go into later. But the truth of the matter is, most landlords don't have the wherewithal to file a civil lawsuit. If you have to hire an attorney, obviously that's going to cost you money. And even if you go to small claims court, in many cases, you're not going to know where your tenant is to serve them. So this myth that the rent is deferred and that the landlord will be able to recoup it even in a civil lawsuit is just that. It's a myth. It's not going to happen. So that's my first discussion with regard to AB 38, the Tenant Relief Act, also known as, of course, the Governmental Assault on Income Property Owners. Let me first tell you that my practice is filing lawsuits. We're filing a ton of lawsuits for evictions. So let me go over the kinds of cases that we can file right now. You know, there's the old adage that there's many ways to skin a cat. Normally, if a tenant wasn't paying the rent, you'd bring forth a simple case for eviction. Well, right now, in a lot of cases, and I'll get into that, we can't really bring forth those types of cases. But there's other ways to skin the cat. And that is, there might be another way that you can evict your tenant, which will solve the problem that the tenant's not paying you rent. So what are those other ways? Well, a popular one is any breach of the rental agreement which doesn't relate to non-payment of rent. So if you have a tenant, and I don't care what jurisdiction you are in the state of California, and who signed this rental agreement and then violates a term of the rental agreement, that might give rise to filing an immediate eviction action where there's no delay. So what kind of issues are we referring to? Pretend the fact that a tenant has brought in extra people and the rental agreement limits how many persons can occupy the property. In that situation, you have the right to serve a 3-day notice to perform or quit. And if the tenant does not remove those unauthorized persons, we go forward with a lawsuit. We've been doing many of those types of lawsuits. Other ones that we can bring forth are if they bring a pet onto the property, or, for example, if they've made an alteration to the property. Maybe they put up a satellite dish. Maybe they've constructed a storage bin in the back of the unit. That's a case I'm doing right now. Those are all breaches of the rental agreement, which would give rise to an immediate case for eviction. So take a look at, I quote, another way to skin the cat, that if you have a tenant who is violating their rental agreement, maybe we can go forward on a breach of that rental agreement, which doesn't involve rent. Now, they put something curious into the law for landlords to, of course, make a mistake and have their case thrown out of court. So let me go over that one other proviso. And that is that when you serve a normal notice to perform or quit, in this case, we'll say that there's extra persons there, and you're giving the tenant 3 days to remove those unauthorized individuals. At the end of the third day, if those persons are still there, you have the right to bring forth an unlawful detainer. But they've added in another requirement. For some reason, it's just for landlords to make a mistake and lose their case. You then have to serve a 3-day notice to quit. A 3-day notice to quit. Now, these are only for properties that are subject to statewide rent control under Assembly Bill 1482. So you'd serve that 3-day notice to perform or quit. If the tenant doesn't comply, then you have to serve an additional 3-day notice to quit. And then at the end of the third day, if the tenant is still there, we have the right to proceed forward with an unlawful detainer action. So those are one type of cases that we can bring having nothing to do with rent, but still will be effective in having your tenant evicted from the property. Another one would be what we call termination of tenancy. That's where you have a lease which expired on its own terms and the tenant didn't vacate. So let's pretend you have a tenant who hasn't paid rent since March, and we're now in November, and that lease will expire November 30th. You have the right to bring forth a lawsuit based on termination of tenancy as soon as that lease expired. You've never authorized the tenant to stay there beyond the lease term, which is November 30th. So even though you haven't gotten the rent, and I can't do anything on the rent at this point in time, and I'll go into the specifics on that, if you do have a tenancy which terminated by its own terms, then we have the right to go forward with an eviction the following day. No notice is served on the tenant. The notice is the lease. The lease says, hey, you have till November 30th and not a day longer. So unless you've authorized the tenant to stay there longer, we can bring forth that eviction. Now, if you had a lease, for example, which expired on October 31st, and you accepted rent for the month of November, you've now created a month-to-month tenancy and we can't proceed forward with that case. So as long as you haven't taken rent past the expiration of that fixed-term lease, we can then bring forth an eviction. So we've had cases where a lease expired in April. Well, the tenant hasn't paid rent since March through November, but since rent wasn't taken and that lease expired in April, we have the right now to bring forth an eviction based on a termination of tenancy. So that's a case that we can bring. Also, of course, all rent that was owed, this is another type of case, where the rent was owed prior to March 1. So if you have a tenant that owes rent, let's pretend from December through February, that's a case that I can bring forth right now. We would serve a standard 3-day notice to pay rent. And if the tenant didn't pay the rent within the 3 days, we have the right to immediately proceed forward with an eviction. Now, you do have to be careful in those types of cases because many times the tenant hasn't paid rent, in this example, from December through February. But March and April and May, they made their payments, but they haven't paid beyond May. But you see, you really can't view that as not paying rent prior to March 1, because when they made the current payments for April, May, and June, let's pretend, that really went to pay the rent that became owed for December, January, and February. So we really have to do an analysis to make sure that really no rent has been paid, and also rent for December, January, or February. If those months truly haven't been paid, we can serve a standard 3-day notice and proceed forward with an eviction. Also, other types of cases that we can bring is for commercial cases. AB 3088, the Tenant Relief Act, does not apply to commercial cases. So unless you have a local jurisdiction, and I'll go into that, which prohibits you going forward on a commercial case. For all those landlords out there who have tenants on commercial leases where the tenants haven't paid, right now we have the right to go forward, serve a standard 3-day notice, and commence an eviction for those tenants. Nothing prevents us because, again, AB 3088, the Tenant Relief Act, as I call it, the governmental assault on income property owners, those do not affect commercial tenancies. So on that basis, we have the right to go forward. Another thing we can do is that this law will be over. And it will be over come February 1st, 2021. When that wonderful day hits, any rent that's owed for the month of February, landlords, residential, commercial, it makes no difference, at that point can serve a standard 3-day notice to pay rent or quit. A standard 3-day notice to pay rent or quit. Now, not for any of the rent that was owed prior, because the guy probably owes you 8 months worth of rent. But come February 1st, we have the right to, if I don't get my February rent, we have the right to bring forth an unlawful detainer by just serving a 3-day notice. So we're in the month of November. So we got about another 2.5 months to go. So just kind of hang on, because those cases we will be able to bring forth. So get your 3-day notices ready to go on that day. Okay, let's talk about our governmental assault on income property owners, AB 3088. Let's talk about that, what the significance is, what's it all about, what we need to serve, and can we bring cases pursuant to that ordinance? And the answer is, let's first talk about 2 important periods, and that is the protected time period and the transition time period. Under the protected time period, we're talking about a time from August 1st from March 1st through August 31st. That's the protected time period. That's why I was saying that we could immediately bring forth a case for any rent owed prior to March 1, like the February rent or the January, December rent. Those cases we can bring forth right now by serving a 3-day notice. But rent owed from March 1st through August 31st, that's considered the protected time period. In that time period, rent owed for that time period under this act, the landlord is prohibited from evicting the tenant. Prohibited from evicting the tenant if the landlord receives a declaration signed under the penalty of perjury by your tenant that in fact his inability to pay is due to the COVID virus. If in fact that declaration is received, then the landlord is prohibited from bringing forth any type of an eviction case now or even in the future. Now or even in the future. All they have to do is fill out a declaration and sign their name to it. No proof has to be submitted with that declaration. There is an exception, and that is where your tenant is what they call a high-income tenant, and you have specific knowledge of that they're earning over $100,000 per year. You can then demand certain documentation. But unless that's the case, no further documentation is required. The landlord, if he receives this declaration, this is for rent owed, between the period of March 1 through August 31st, cannot ever collect rent. I'm going to go into what you can do, but it will never be the subject of an eviction action, as all they merely have to do is send you this declaration. And if they do, then in fact, you can never bring forth an eviction action based on rent owed from March through the end of August. Let's move on to the transition time period. The transition time period is from September 1 through January 31st. Remember, this is over on February 1st, okay? The transition period is from September 1st through January 31st. In that case, the landlords are prohibited from bringing forth an eviction if the tenant has submitted a declaration under the penalty of perjury stating that for that time period that they had an inability to pay because of the pandemic. If they submit that declaration, then you are barred from bringing forth an eviction as to 75% of the rent that's owed. That's the difference. For the transition time period, the tenant has to pay 25% of the rent. As to the 75% of the rent, you are barred from ever bringing forth an eviction. Again, all they have to do is fill out that declaration, give it back to you, and pay 25% of the rent. If they do, then you are barred from ever bringing forth an eviction based on that 75% of the rent. I'm going to get into when you have to pay that, but I just want to make sure that everybody understands that for the protected time period, that's March through August, if I submit that declaration, I can't bring forth an eviction against all rent owed from March through August. For the transition time period, the tenant from September 1 through January 31st, the tenant has to return that declaration, and if he does, then only 25% of the rent is due. As to 75% of the rent, so if you've got rent and the rent is $4,000 per month and he didn't pay, let's pretend for the month of November, he'd only have to pay $1,000, assuming he declares under the penalty of perjury in that declaration that his reason for not paying rent was due to the pandemic. Okay, now we understand what these two time periods are, what we can and can't do. Let's talk about what needs to be served on the tenant. And we can take the example where rent was owed during both time periods. I've got so many clients, rent hasn't been paid since March. Well, the March, of course, March through August would be the protected time period. And then, of course, the transition time period from September through January 31st. If you have a tenant that owes rent in both periods, you have to serve not one, but two 15-day notices to pay rent or quit. Take out all your 3-day notices and throw them into the garbage because they're not going to become applicable until February 1. So you would have to serve not one, but two 15-day notices. So one notice, and our example is in this situation that the tenant did not pay rent from March through the end of November. So in that situation, one 15-day notice would be for the period of March 1st through August 31st. Add up all that rent. You have to specifically state what became due on what day. So for example, if the rent's $1,000 per month, you have to list March 1, $1,000, April 1, $1,000, May 1, $1,000, until you get to the end, which would be August 31st. Of course, you have to have a total for the amount of rent owed. And of course, you have to follow the requirements that are in any 3-day notice where you have to have an address where to pay the rent, a person's name, times when payment can be received, and also, of course, a phone number that has to be included. The same thing is true for the transition time period, where you are having rent owed, again, from September through the end of January. You'd have to have a separate 15-day notice for that. Again, listing specifically that rent was owed $1,000 for September 1, $1,000 for October 1, $1,000 for November 1, and then the total, which would be $3,000. So not one, but two 15-day notices. Each of those notices must have with it an information sheet. The information sheet basically tells them that for the protected time period, that all they have to do is fill out that declaration, and then their rent is, quote, deferred. But we know rent is never deferred. Rent is going to be forgiven. The same thing is true for the 15-day notice for the transition time period, that information sheet, a separate one, will inform the tenant that you do have to pay 25% of the rent. 25% of the rent. Now, you also have to include, so you got the 15-day notice, the different information sheets, one for the protected time period and one for the transition. You also have to have the declaration. This is a declaration that all the tenant has to do is sign his name and date it. That's it. If he signs his name and dates it and gets it back to you within the 15 days, then he's complied with the statute and his rent is deferred. So you have to have a declaration for each notice, and on the declaration you should specifically state the time period in question. So if rent was owed, for example, from April through August, you'd write that right on the declaration that he has to sign saying, hey, for the period of April through the end of August, I lost my job. I had an inability to pay because of the pandemic. The same thing is true for the declaration that you're going to serve with the transition time period. You're going to put that period on, so that would show the declaration is for the months of September through November. Put that date right on that form so the tenant is committing under the penalty of perjury that for that time period he didn't pay the rent. So with each of these time periods, we're serving a 15-day notice, an information sheet, a declaration which specifies the exact time period for which it's owed. You also have to serve on them the state form dealing with the notice under the Tenant Relief Act. And again, notice they didn't call it the Landlord Relief Act. You have to serve the state form. That's under 1179.04 of the Code of Civil Procedure. So that's just a form that has to accompany each of those notices. So if you think about it, each, like a normal 3-day notice, you served it. It was a 1-page form. Now you're up to 4 pages. So you've got the 15-day notice, you've got the information sheet, you've got the declaration, and you also got the state form dealing with the Tenant Relief Act under CCP 1179.04. So 4 different documents need to be served on the tenant when you serve that, okay? Now, curiously, if you did serve a 15-day notice now because the tenant hadn't paid rent for September through November, you're going to need to, on this crazy, insane law, and that's what it is, crazy and insane, you're going to need to serve an additional notice for December and an additional notice for January, because you want him to commit that declaration for all of those months. Okay? So you're forced to serve a notice basically. So if you did this right at the beginning and you served one for September, you got to do another one for October, November, December, and January. So you're just serving notices month after month after month. Now, if you do not receive the full payment, we're moving on. Now we've served our notices, and the 15 days have come and gone, and you haven't received anything. You haven't received the full amount of rent from your tenant, and you haven't received the declaration back. If that's the case, then you have the right to bring forth an immediate eviction right now, today. Okay, you served your 15-day notice. I didn't get the full amount of rent. I didn't get the declaration. So we can bring forth an eviction action right at this moment. Now, there is a proviso. The way they wrote this law is that if you did bring that lawsuit, you filed the eviction lawsuit, I didn't get my declaration, I didn't get my rent, and I properly served all those documents that Dennis told me to serve. If after the tenant is served with the lawsuit, that's an unlawful detainer, the tenant can file the declaration with the court. And if the tenant does, the court has to have a hearing within 5 to 10 days to see if it's excusable neglect. I kid you not. Excusable neglect as to why the tenant didn't give the declaration within the 15 days. And if the judge finds that it was excusable neglect, then your eviction case is dismissed. Now, thankfully, we have hardly got any of these, though I just got one the other day from the Legal Aid Society, so I'll be able to tell you shortly as to whether the judge found excusable neglect. But incredulously under this law, if in fact the judge does, our case is dismissed, which means that you went through the expense for nothing, all sanctioned by our wonderful governor and the California state legislature. Our governor signed this into law. Okay, but let's pretend that the tenant paid you the full amount of rent. Well, after you finish getting up from the floor because you've obviously fainted, okay, at that point in time, then everything is fine. You've gotten your rent. The tenant has complied. So there's two ways the tenant can comply: pay the full amount of rent as required, or sign the declaration and get it back to you within the 15 days. But what happens in those cases where the tenant has signed the declaration and has returned it to you within the 15 days? What happens next? The guy still owes me the money. Well, the legislators and our wonderful governor has declared that that's not rent anymore. This is for the protected time period, that 15-day notice that you serve for rent that was owed somewhere between March through August 31st. If in fact you get that declaration back, the tenant under the statute does have to pay you. He's got to pay you by January 31st. But you can never, emphasis added, never bring forth an eviction based on non-payment of rent for that time period. Never. Because you see, the legislators have now declared that that rent that's owed between March through August is now considered a civil debt. They now call it a civil debt. Well, they were very insidious as to the reason why they called it a civil debt. They called it a civil debt because now it's not rent. And if it's not rent, then you can't bring forth an eviction. So you might think, well, gee, this is all going to be over in February, so maybe February 15th, I'm going to serve a 3-day notice for all that rent owed between March and August. You can't, because it's not rent anymore, because the legislators have determined this to be a civil debt and have taken it out of the category of rent. So then how do you get your money, one might add? Well, it's due on January 31st. You could walk up to the tenant, assuming he's still there, hasn't moved away, and you can say, hey, rent's owed now, pay me. And of course, the tenant just laughs, is what will happen I would imagine, in countless cases. And therefore, you can bring a civil lawsuit. Well, that's nice. First of all, you can't bring a civil lawsuit until March 1. The difference when he owes the rent January 31st and when you can finally sue him. Well, of course, what's going to happen between January 31st and March 1st? Very simple. Your tenant will probably leave. Because you see, on March 1, you can either bring forth a regular civil lawsuit or you can bring forth a small claims court lawsuit. The jurisdictional limit of small claims, which is normally $10,000, has been waived. So those clients out there and members out there where the tenant will now owe rent in excess of $10,000, $15,000, $20,000, $50,000. I see horror stories after horror stories. You can, on March 1, bring forth a small claims court action or a civil action against your tenant. But what if the tenant has moved? You could certainly file the lawsuit, but in order to go forward with the lawsuit, what you're going to need to do is you're going to need to serve him. Well, how are you going to serve him if you don't know where he is? Now, of course, if you know where he is, you can bring forth a lawsuit. But what if you don't? And that's what I'm talking about. This is not rent deferment. This is government-sanctioned rent abatement and forgiveness, where you will never be able to collect this rent. But let's pretend your tenant hasn't moved. He's still there. And maybe he's paid the February's rent, so there's no way to bring forth an eviction. You can go on March 1 to the small claims court or hire an attorney to do a civil lawsuit, and we're happy to do that. But you see, if we bring forth that lawsuit and you sue him in small claims court and you win your case, as you should win your case, you now have something called a judgment. But a judgment is not something that you can go to your local market and buy groceries with. You have to turn that judgment into cash. How do you do that? Well, you can garnish wages, assuming you know where the tenant works, or assuming the tenant is working. You can attach a bank account, assuming you know where a bank is to attach and assuming there's enough money in there. You can give it to a collection agency, but they generally will take 50%. And if they're lucky enough to find your tenant, maybe collect somewhere down the line. But the truth of the matter is most landlords are probably just going to be happy that the tenant vacated or that the current tenant is paying rent. So as I was saying, we're talking about true rent forgiveness. Let's talk about now where they returned the declaration, but we're now talking about the transition time period. Again, that's from September 1 through January 31st. So you got it. Now, logic would tell you that if you serve a 15-day notice, that the tenant would have to return the declaration within the 15 days, but for the transition time period, they have to pay you 25% of the rent. So logic would tell you that that 25% is due within the 15 days. But that would be logical. And this has nothing to do with logic. This has to do with socialism, which is what we're dealing with right now. And that 25% of the rent, remember we're saying for November, rent is $4,000 per month. You serve the 15-day notice. All the tenant has to do is return the declaration within the 15 days. Not the 25% of the rent, the small amount of $1,000. So when is that due? Well, that's due on January 31st. Now, if by January 31st the tenant doesn't pay the 25%, then on February 1st you can then file the eviction lawsuit based on that 15-day notice that you served in November. Well, that's nice, but let's pretend the tenant pays it by January 31st. In that situation, the 75% of the rent, or the $3,000, now becomes a civil debt, which means you can't bring forth any eviction action based on that 75%. You can bring forth again that civil lawsuit come March 1, either small claims court or a regular civil lawsuit, but it is not considered rent. So unless you have a good way of collecting on this civil debt, you have no basis of ever seeing your money. That money's just lost, ladies and gentlemen. Again, it's government sanctioned taking of our rent. And you know, it reminds me of our government, which is shutting down all these stores and restaurants, and they're not allowing businessmen to keep their stores open. And they're forcing them to close their stores, safety reasons because of the pandemic. So think about it. The store is closed, and the owner of that store, the businessman, cannot sell his goods or services. He's stuck. But now let's think about income property owners. Our doors are forced to be kept open, and our goods and services are forced to be distributed without any hope of payment. So it's different. At least the restaurant doesn't have to give away free food, but landlords certainly do. And that's why income property owners are certainly a different segment under the law than any other business or industry. Okay, so we've already received the declaration. We know that we have to get our 25% for the transition time period come January 31st. Otherwise, we can bring forth a lawsuit. Otherwise, for eviction based on the 25%. The 75% is a civil debt. All the rent owed where a declaration was received for the protected time period, that's now a civil debt and basically lost. Okay? All right. There's another point that I need to make now that we somewhat have gotten a handle on the Tenant Relief Act. And that is, notwithstanding the Tenant Relief Act, if you have a local jurisdiction which has their own eviction moratorium laws, then you have to comply with that. So, for example, some local moratoriums state that if the tenant tells you, indicates to you in any way, shape, or form, and many local jurisdictions have this, then you are barred from collecting rent. So you can't serve that 15-day notice with that declaration. That's the state law. You have to determine, ladies and gentlemen, whether your local jurisdiction from the city of San Francisco to San Luis Obispo to Los Angeles to Long Beach to Orange County, you have to determine whether you have a local jurisdiction which has an eviction moratorium rule. If it does, then you've got to comply with that because the Tenant Relief Act states that. If you're in a local jurisdiction which doesn't have a local eviction moratorium, then you're free to comply with the state law. Let's serve our 15-day notices. Let's see. And by the way, if you have the ability to serve the 15-day notice, if you're not prevented by a local eviction moratorium, then you need to serve those 15-day notices. That's something that my firm can assist you with, or you can do that yourself, but that really needs to be served. We need to have the tenant commit under the penalty of perjury that he has an inability to pay due to that. So those notices need to be served for every single month from March 1st, 2020 through January 31st, 2021, that the inability to pay was due to the COVID. If you don't get that declaration, lawsuits should be filed. And also, of course, we have a laundry list of other types of cases, other ways of, quote, skinning the cat, that we can bring forth other types of evictions at this time. As a last aside before I open it up to questions, generally speaking, if you have a property that is not subject to any local rent control ordinance or not subject to the statewide rent control, which is AB 1482, normally you would be able to terminate a month-to-month tenancy by serving either a 30-day notice or a 60-day notice. So let's pretend you have a house. It's not subject to any rent control, either a local jurisdiction or a statewide rent control. And let's pretend you get the bright idea that you've had enough with California, that you want to move to a civilized state which doesn't have state taxes. And you want to sell your house. Well, if you have a tenant in possession of that house under AB 3088, the new Tenant Relief Act, you cannot just issue a 30 or a 60-day notice to that tenant. You have to have good cause. Good cause is not, I want to get out of this state, okay? Good cause would be if you want to move in or a family member wants to move in, or if you sold your property and it's in escrow and the buyer wants to move in. In that case, then you can issue that. But other than that, and I get this all the time, where I have a single family home, I just want the tenant to move. I want to put it up for sale. You cannot, under the Tenant Relief Act, you cannot request that that tenant move. You're going to need to wait until at least February 1st, where you're entitled to, at that point, go for a judgment for eviction in that situation. So I hope I didn't confuse everybody. If anybody does have any questions, of course, they can call them in right now, or you can call our office. I think you see my 800 number, which is 1-800-77-EVICT. That's EVICT. I do have a website, which is evict123.com, where you'll be able to get a lot of our legal issues and forms, etc. But now, Jeff, I think we're going to open it up to questions. So don't hurt me. Ask me some nice questions, okay?
All right. Thank you so much, Dennis. We really appreciate it. And, you know, a lot of the questions that you guys, I see some of these questions here. A lot of them, he even answered these questions in the November issue of the magazine. but we're going to answer them anyway. And just to remind you that, hey, there is a resource there, and he's a great resource. Here we are. We have first one that's up here. We have Mark Williams. How is AB 3088 and other such laws constitutional? Can the state be sued in federal court?
And the answer is, I do not believe they're constitutional. I think it violates the contract clause for the United States Constitution. I also think that it violates the Constitution because this is definitely a taking. You might call it rent deferment, but the truth of the matter is this is rent forgiveness, state authorized rent forgiveness. Maybe they should put in the statute where that if you don't get your rent after 1 year, that the state will pay you for it. But I don't see that in the statute. So yes, I think this is unconstitutional, and lawsuits, I believe, have already been brought on this topic.
Okay, next one, YouTube. They may have asked this question a little early. You covered it, but I'll just read it. Here's, are courts taking unlawful detainers currently?
The answer is they certainly are. So even where you've served a 15-day notice and the tenant hasn't complied, or for those other reasons rent owed prior to March 1, where a normal 3-day notice was served, or other breaches of the rental agreement, like having pets or additional persons or alterations. You know, the tenant decides that on a particular day, he just wanted to paint every wall black in your property. You know, and he just took out his paint cans. That would be a 3-day notice to perform or quit, demanding that the tenant paint it back to its original color. If he doesn't, we could bring forth that lawsuit. Again, we would have to, in that situation, serve an additional 3-day notice to quit. Don't forget about that. Also, we can bring forth an eviction based on termination of tenancy, where the lease expired by its own terms. You never gave the tenant permission to stay beyond that. So the answer is yes, we can bring forth all kinds of evictions, and we certainly are. In fact, we have right now, today, we have about 7-8 trials going on right now.
Great. Yeah, and this one, in the chat, Victoria from Los Angeles asked, what could happen to the landlord if they didn't give the tenant the Notice of Tenant Relief Act? Well, and this they had late rent beginning in November.
Okay, there was a form, the Tenant Relief Act form had to be served by September 30th. And if landlords didn't do it, because I don't think it was well publicized, so how would landlords even know to do it? I mean, the AOA had it on their website and I had it on mine, and we tried to get the word out. But the reality is there's really no harm, no foul. If you haven't done it, please serve it now. And obviously, if you serve a 15-day notice to pay rent, you're going to need to serve it with that. So there's no penalty if you didn't serve it. They're not going to take your property away, though. They're trying to take it away in other ways, though.
Great. Okay. And here's one from Melody on YouTube. I'm a landlord that will be receiving $2,000 from LA to pay rent for a tenant. First question, is there any reason not to accept money?
In the city of Los Angeles, they do have reasons that you can't bring forth an eviction for 1 year if you accept that rent. It also states that you can't raise rent for 1 year. I have mixed feelings on this. I was presented with this myself, and I chose not to do it. I always want the ability to evict the tenant if I can, if there's something that the tenant's doing. They're limiting it to the transition and the protected time period, but I just thought that there was too much governmental intrusion to take a maximum of $2,000. So I chose not to do it, but it is a business decision. And if you want to take it, take it.
Great, thank you. Here's Dave on YouTube in SFR. Can I have a tenant take a moving out bonus and sign an agreement when they will move out? Right now they're a month-to-month tenant.
For a single-family residence or even a property that is subject to statewide rent control or a local rent control jurisdiction, in those situations, you can certainly enter into we call it a voluntary vacate agreement. A lot of people call it a cash for keys. There's nothing illegal about that. Two men can certainly contract together, and that's what we have here.
Great. Okay, and here's a follow-up. believe you answered it, but let's just hit this one more time. Can the 2K be used to pay for rent during the protected period or only the transition period?
That's an interesting question. I would, of course, apply it if there's no statement as to what it's for. Then I would apply it towards the protected time period, because obviously I'd be entitled to get at least 25% of my rent for the transition. However, the law specifically states that the debtor decides what debt he is paying. So if the tenant tells you, hey, this $2,000, I'm applying it towards the transition time period, then the creditor, that would be the landlord, has to apply it towards that period. Now, I haven't seen this, but maybe the city, when they're issuing these checks, are going to state what month they're stated for. If that's the case, then you're going to have to apply it. But I doubt that they do. And if there's nothing stated, I would definitely apply it towards the first rent that became due, which is obviously the rent between March through August, the protected time period.
Great. Okay, and here we have on YouTube Dave. When I donate a duplex to a charitable organization, can I give a 60-day notice for tenants to move? It's not in rent controlled, not on rent control or a lease.
Well, a duplex would be under statewide rent control. You'd have to have good cause to evict. If, for example, it was a newer building built after 2005, so it's not subject to any rent control, could you issue a notice to quit? The answer is, well, not now, because we're still in this protected time period under the Tenant Relief Act, and you're going to have to wait till February 1. February 1, you'd be able to do it. The issue of donating it to a charity doesn't add or detract anything from the equation.
Great. And in the chat on the AOA page, Victoria, she has this question. What will happen if a landlord sends the notice of Tenant Relief Act at the same time as the 15-day notice? Another lawyer mentioned that landlords were not supposed to send the Tenant Relief Act at the same time as this 15-day notice. What's your thoughts?
Well, technically, you're supposed to serve that notice prior. You were supposed to serve it by September 30th. And if you didn't, I don't have any problem serving it all at the same time. So I don't see any problem because of that. And when you say that it has to be served beforehand, well, what's beforehand? In other words, if I post the notice on the door 1 second before, didn't I do it before? So have it on the bottom of the pile, that tenant notice. So when it hits the door, when you post and mail it, then that got served first. I mean, it's insanity, these laws and the way they're written.
Great, thank you. On YouTube, we have Gurr Media. Tenant put property on Airbnb without authorization. Lease clearly prohibits subletting. What action can we take to stop and evict in the current environment?
The current environment allows you to immediately bring forth a regular old eviction case based on an illegal sublet. We do those cases all the time. We would serve a 3-day notice. Then we're going to need to serve to perform. Then, of course, now we're going to need to serve a 3-day notice to quit. And again, these are only for properties subject to statewide rent control. You don't need to serve that additional 3-day notice to quit if your property is subject to, for example, the San Francisco Rent Control Ordinance or the Los Angeles Rent Control Ordinance.
Great. All right, moving on. Here we have on YouTube, Anna Cecilia. Nowadays, is it better to get a tenant month-to-month on a month-to-month lease rather than a year-long
If
lease?
your property is subject to statewide rent control, if the tenant's been there for a year, you now need good cause to evict. So on that basis, I don't recommend giving 1-year leases anymore, because if the tenant shows colors that you don't particularly like to see, he's very argumentative, or he's creating disturbances, now you're going to need to have good cause to evict. You're going to have to go through a trial to prove that. So therefore, if he's on a 6-month lease, he'd have to vacate at the end of the 6-month period. So if your property is subject to statewide rent control, I would recommend doing a 6-month lease and not a 1-year lease.
And then go month-to-month after that?
Correct.
Yeah, okay.
But
great.
once they're there longer than 1 year, regardless, then you're going to need to have good cause to evict under the Tenant Rent Act.
Great. All right, Teresa on YouTube. For rent-controlled buildings, if a tenant left the unit and didn't pay rent for from March to October, can we report it to a collection agency?
Good question. And the answer is, if the state has sanctioned that the rent is not due until January 31st, and you can sue on March 1, then you're reporting a debt that is not overdue. It's not delinquent. So even though your contract says it's way delinquent, the guy hasn't paid me rent since March, the truth of the matter is, under the rewritten aspect of your contract, rewritten by Governor Newsom and our state legislators, the rent's not due. So it would be like reporting someone to a collection agency for rent due in December of 2020. The rent's not due yet, so you can't report it. That's my analysis.
Right, and that's even if they've left the unit.
If they left the unit, then you have the right to then report it.
Great, okay.
At that point.
That's the big key there. Great,
Yes.
glad you hit that one. Okay, Carla on Facebook. What about if a tenant has been paying half the rent since April? I already sent the 15-day to pay rent or move out.
Well, if they return the declaration, you served a 15-day notice for the correct amount of rent that's due because they've made partial payments. They still have to return the declaration to you within the 15 days. If they don't, then you have the right to go to eviction court. If they do return the declaration, then they owe it to you come January 31st, and you can sue for the remaining portion on March 1. I would love to see the percentage of landlords as of March, and maybe within even a year thereafter, where they actually get paid on all this rent. And the answer is, I think the percentage will be less than 10%, which means this is state-sanctioned theft of rent from landlords. State-sanctioned.
Okay. On YouTube, Teresa is asking, if you need the rental unit for a family member to move in, what requirements are needed with the new laws? Do you need to, yeah, I'll just let you answer from there.
I'm not sure I understand the question. You're saying...
So they want to move in a family member, and with AB 3088, what procedure would they have to go through?
You can move in a family member. This is for a property that's not otherwise subject to a local rent control ordinance, because that would have its own prohibitions potentially. But for a rent controlled, either subject to the statewide rent control or not subject to any rent control, you can accomplish that under the Tenant Relief Act by serving either a 30 or a 60-day notice. You have to state the reasons. And if it is subject to the statewide rent control, you'd have to pay relocation equal to 1 month's rent.
Got it. Great. All right. Here we have Lee on YouTube. Can I give a 30-day notice to raise rent on February 1st?
On February 1st, you are certainly able to raise rent. If your property is not subject to a local rent control ordinance which prohibits rent increases, you are free to raise the rent. If you're not subject to any rent control, you can raise the rent to any amount that you like. If you're subject to statewide rent control, right now, today, you don't have to wait till February, you can serve a rent increase notice under the state law. It's 5% plus the local CPI.
Great. Okay, very good. And here's Victoria in the chat. Do you think the CDC order applies to California? Some say that it doesn't apply because California already has eviction protections. Others says that both apply.
And the answer is, it does not apply. However, we've had some judges believe that it does. So we have beaten them down in court in many cases, but we have been unsuccessful in front of a couple of judges that I don't think are reading the statute correctly. So what we're referring to for the audience is that the Center for Disease Control has issued a statement that states that nobody can be evicted prior to December 31st. That doesn't mean we can't file an eviction lawsuit. It just means that they don't want you physically evicted by a sheriff until that time. Now, the sheriff's offices are conducting evictions at this point in time. So their county council or their local area have stated that we can go forward with these. Some judges are saying, no, we can't. But that's what this law is about. But if, in fact, under the CDC law, it states that if a state has their own eviction protection, then the state law controls. So that's what we're proceeding on, and I don't think the CDC law has any effect for our liberal state of California.
Great. Okay, on YouTube, we have Gilbert with an RSO unit tenant has a second unauthorized dog. What are my percentage? What's my percentage of my chances of winning an eviction in this case?
They're excellent. We've brought forth many cases, and we've been successful under the new laws that are in existence based on an unauthorized pet. So I don't have any problem with that, and that's a good case. Now, if the dog doesn't bother you, then you're probably not going to want to bring forth this lawsuit. But what if the dog doesn't bother you, but you've got rent that's been owed from March through the end of November? You know the tenant's going to work every day. You know he has the ability to pay the rent. And you know the funny part is I've had so many landlords call me and say, he's not paying the rent, but he's got a brand new car in the driveway. I've heard this story so many times. So in that situation, maybe the second dog's not bothering you, but again, it's another way that you can rid yourself of this tenant by bringing forth an action based on a breach of contract as a term under the rental agreement, which doesn't include rent.
Great. And here's Victoria in the chat in Los Angeles. Is there any talk of the state, city, federal government assisting landlords with their current financial burdens?
Don't hold your breath, Victoria, is all I can tell you. No, there's no protection for landlords. Landlords are not looked at differently than every other segment of society. As you can tell from these laws, there's no one being forced, no other industry is being forced to subsidize another segment. And individually, we're not asking all the taxpayers to do this. We're asking this specific landlord who has a duplex, lives in one side, and depends upon the rent to make his payments, to feed his family, but that landlord is asked to individually donate rent to his tenant. There's nothing under the law that for any other industry.
Yeah, so too bad there's not a good acronym for government assault on income property owners. It doesn't make a great acronym, but that's basically what 3088 is.
I'm sure somebody will chat it in the chat room.
All right, and here we have Jim Robinson on YouTube. My tenant, he's in Los Angeles RSO building. He lost his lease, and so is he obligated to give that tenant a copy of his lease?
Yes, I think you are. If the tenant is asking for a copy of his lease, I would give it to him.
Great, and here's Nikki on YouTube. Does the recent court win in the case Gallagher and Kiley versus Gavin Newsom help landlords?
I'm not familiar with that case.
Okay.
But I'll put that in the...
It's James Gallagher, and yeah, I don't know it well enough to go through it.
I'll write about that in the next issue of the...
there we go.
The magazine.
Yeah, I believe it's James Gallagher. All right, here we go. And it's about the order, the lockdown orders. So here we go. Monica on YouTube. My tenant only started paying in October, not September, the 25%, and filled in the declaration because he said he is protected by LA City law over AB 3088. What can we do?
Well, under the Los Angeles rent control ordinance and their eviction moratorium, if the tenant has told you that his ability to pay rent is limited by the pandemic, then in that situation, landlords can't do anything. since you've raised the specific jurisdiction of Los Angeles, under Eric Garcetti's edict, if the tenant is in any way, shape, or form, sent you a text, did smoke writing, did something to indicate to you that he has a problem paying the rent because of the pandemic, then the landlords cannot do anything. The rent is deferred. In Los Angeles, it's going to go through January 31st, which means that that rent will now become owed to the landlord as of February 1st, 2022, 1 year later. Go try finding that tenant, by the way. But this is under the specific Los Angeles. We're not talking about the state. But remember, the state Tenant Relief Act, that particular one states that in the body of that you have to comply with a local jurisdiction. So for landlords in Los Angeles, they are truly being assaulted by the government.
All right, on YouTube we have Lost Domestic Arts. Do you have to participate in Section 8 program if the tenant hasn't paid any rent in 9 months and now wants you to accept this?
Well, of course, if you so what you have is an existing tenant, and the tenant now wants to get onto the Section 8 program. Do you have to do it? Well, under the law, you do have to accept a Section 8 tenant. You are allowed to screen them for their credit worthiness, but since the tenant is already your tenant, and this is kind of an interesting question,
That is.
then I think you would be duty bound to accept the Section 8 contract. At the very minimum, though, it might be to your advantage because Section 8 will probably pay the lion's share of the rent, so at least you'll be able to get some rent. But I think you're kind of stuck accepting it in that situation.
Okay. Monica on YouTube. The only proof that we have he is high income tenant is when he signed the lease in 2011 with $96,000 a year, and he paid regularly until April of this year. And now, how can we prove that he's high income?
Well, you're really not going to be able to, and you have to have specific proof that the person is making more than $100,000. So the only proof you have is that he's not making $100,000, and that was from so many years ago. So I don't think you can ask for further documentation.
Okay. All right, on Facebook, we have Christine. I understand that there are 3 exceptions to TRA. One being ownership by LLC corporation. Hence, UD could proceed after a 3-day notice to pay rent or quit. Please confirm if that's right or wrong.
Not sure I understand the question.
I think the Tenant Relief Act is. They're wondering. It seems like they're wondering if the if they're exempt to Tenant Relief Act based on if they're an LLC.
Okay, if you talk about statewide rent control, if you have a property that is not under statewide rent control, like a single family home, you can own that home as an LLC and you still will be exempt. But if it's held in a corporation, then you, where it would otherwise be exempt from statewide rent control, you are now subject to statewide rent control.
All right. And in the chat, Victoria, in Los Angeles, how should landlords follow up with tenants who have already moved out, who owe money from the protected or the transitional period?
Well, at that time, you can if they moved out, they've lost some of their rights, and you can bring forth a regular civil lawsuit. Obviously, it's not an eviction because they're already out. So you can bring forth a regular civil lawsuit. If you wanted to do it in small claims court, and the amount was more than $10,000, you might want to wait until March, where the jurisdictional limit will be unlimited in small claims court.
Okay, what was that date again?
March 1st, 2021.
Okay, that's a good date. Okay. Does the LA County moratorium protect occupants, or can 30-day notices be served?
The LA moratorium does protect for property that is not under any local rent control for the city of Los Angeles, does protect them. You need to have good cause to evict in the city of Los Angeles. Okay. So you just can't say, I'm selling my place and I need you out. That would not be a proper reason, even though your property, let's pretend, was built in 1990, so it's not subject to the Los Angeles rent control ordinance, you still have to have good cause to evict.
Okay. And here we have Frederick Lewis on YouTube. In San Francisco and Oakland, if they return the declaration during the second time frame and do not pay the 25%, do I have to wait until March to start the eviction?
No, as I stated, you can start the eviction as of February 1. The tenant has, under the law, till January 31st to pay 25% of the rent or face eviction based on that 15-day notice.
All right, and Maria on Facebook. What about LA City RSO tenants? The city protection doesn't allow us to do anything. Can we serve 15-day notice to LA City RSO tenants?
And the answer is, as I've explained, we have to comply with the local jurisdiction. So if the tenant in any way, shape, or form, he just merely told you, hey, I lost my job, or they cut down my hours, or I have to stay home with my kids so I can't go to work. If they've indicated that to you, you are out of the statewide rule, you're in the city rule, and you can't serve any 15-day notice whatsoever.
Okay. Sorry. It's just so unfair. Okay, Dazzle Spoon on YouTube. It seems like your firm will be filing tons of civil lawsuits as of March 1st. Would you be able to give us an approximate cost? So you'll have to give you a call, right? Or do you have a cost?
Give us a call on that. But I am going to, we've already discussed this at the firm. We are going to have special pricing for this. It's going to be a very standard lawsuit that we're going to be filing. So it'll be a very competitive fee.
Great. And on YouTube, we have Raphael. I understand courts are now open and hearing cases not related to COVID, but is there a big backlog? Is there a big backlog? I'll ask that one first, and then I'll ask the second
question. And the
question.
answer is no, because there are so many landlords that don't realize that they can bring forth eviction, that there hasn't been that flood right now. I agree with you, come February there will be, but there hasn't been the flood of evictions right now. So we're getting to court actually quicker than we normally have done.
Okay. And on that one, if there's a breach of the agreement that's not related to rent, they could proceed with that immediately.
Absolutely, and we're
then
encouraging people to do
how long
that.
would that process? He's kind of curious. How long would it take?
You know, a general case is taking anywhere from 4 to 10 weeks, depending on what the tenant does or doesn't do during the course of the lawsuit.
Okay, great. And then on YouTube, Steve, let me see, the 15-day period is business days, skipping holidays too, not calendar days, right? That's a good question. So
yes,
how do you count those 15 days?
Okay, yes, I was actually meaning to discuss that, so I'm glad the person raised the issue. You know, they tell you a 15-day notice. We're used to like a 3-day notice to pay rent or quit, right? So the legislators then did a 15-day notice. Like, how much time do we need to give to the tenant, right? But then they even added on another 6 days, approximately, because you have to skip Saturdays, Sundays, and legal holidays. So a 15-day notice really is around 23 days if you count it out, actual calendar days before the time period runs.
All right, here's one from Reliable Document Services. I filed a case for termination only. The court did not issue the summons due to the halt. Now they are asking for me to submit the summons with the new form UD 101. What do I do?
Fill out the form UD 101. The legislators came up with another form that's required in order to proceed forward with any eviction actions. So there was a standard unlawful detainer complaint. Now there's an additional form that needs to be complied with by filling that form out. It's basically telling the court all the aspects of whether you complied with the Tenant Relief Act or not. So it's another additional form. So we've had to send to our clients where we were waiting to file, and now this form just became out as of October 8th. So we've had to send additional forms for our clients to sign so that we can get these lawsuits properly filed with the court and allow us to proceed forward with the eviction.
Great. On YouTube, Ming Chen is asking, the lease expires on January 31st, 2021 on my single family house. If I send a notice to the tenants to terminate tenancy without cause now, plus also AB 3088 is extended, can I serve another notice with a cause?
I don't believe the legislature will extend AB 3088. I think it's going to be over as of January 31st. This law was passed and codified. I don't see them changing it. You don't really need to serve, quote, a notice to quit to a tenant whose lease is expiring on January 31st, 2021. You just merely need, as a courtesy, to send him a letter explaining to him that your lease expires January 31st. I will not be renewing the lease, and we expect you to vacate at that time. This has nothing to do with rent. And if the tenant doesn't vacate, you'd be able to file, without any other notice, you'd be able to file a lawsuit come February 1.
Great. Okay, and then on Facebook we have Maria. What if the rent was deferred by LA City ordinance in the protection period? How do we proceed with new state law? As it in conflict with local conflict with local ordinance.
It's not in conflict in that the state law requires that you comply with the local law.
Yeah.
That's the confusion, and why I see so many landlords in Los Angeles, for example, or in other jurisdictions serving 15-day notices when they really don't have the right to do so under the local jurisdiction. That's why I really don't recommend serving your own 15-day notice. You should hire a professional such as our firm to assist, because you got to first analyze whether the local jurisdiction prevents you from doing that. And these forms can be a little bit tricky. But so there really is no conflict. You just have to comply with the local jurisdiction.
Great. And here's a good question. So Dennis, what is being done regarding class action suits alleging a taking in violation with the Fifth Amendment?
I think there has been a couple already filed, and they're working their way through the courts. But it definitely is a taking, and it's definitely against the contract clause. They're rewriting our contracts, and it's definitely a theft.
Yeah.
Again, going back to the analogy where it's bad enough that the government is forcing shop owners to keep their stores closed, but at least they don't have to give out their merchandise.
Yeah.
But for landlords, our stores have to be kept open, and we have to supply our goods and services without any payment.
All right, next question from Ming Chen on YouTube. Can the collection lawyer help to collect the rent without going through the small claims court?
Well, any collection agency can attempt, and basically when you have the legal right to do so, you can send letters to the tenant making demands for payment. You can turn them into different credit institutions. But the reality is, if you want to get your rent, and if those factors don't produce the debt being paid, then you're going to need to file a lawsuit, either small claims court or a civil lawsuit.
And can the collection lawyer represent the landlord in small claims court?
No. Small claims court is only for individuals. You cannot be represented by an attorney.
Okay, good. And then on YouTube, Carl, can you discuss the year to pay after the pandemic is declared over? Is that still the projected rule?
Well, again, under the Tenant Relief Act, it's over as of February 1, and you can then sue for the money come March 1st if the tenant hasn't paid you. Technically, under the rule, you've got 1 year. That's another little whack at landlords. You've got 1 year to file your lawsuit. If you don't, then under the, quote, statute of limitations, it now is considered to be waived. So think about it. If you have a tenant who walked out on a lease, general regular contract, you have 4 years to sue for the money. So here, under the Tenant Relief Act, you have to bring forth, if you don't get your rent, you got to bring forth a lawsuit by March 1st. You got 1 year to do it. 1 year. And if you don't do it within the 1 year, then your debt is considered waived under the statute of limitations.
Wow. Okay. Here's Scott on YouTube. If I choose to sue in March for unpaid rent for either or both periods, can I sue for the entire unpaid amount? And yeah, I'll let you answer that first. Then there's
And
a
the
second.
answer is absolutely yes. One
Okay.
lawsuit for the entire amount owed, whether it's the protected time period or the transition time period.
And must I have served any of these notices in order to be able to sue?
Nope, you don't have to serve anything. You can
Great.
go bring forth a civil lawsuit.
All right. All right. Here's Lee and
One
Pat.
thing I wanted to
Oh.
add is if you were in a local jurisdiction, this is something that they didn't anticipate. So let's pretend you're in a local jurisdiction which says, your rent's deferred for 1 year. And you don't have the right to serve a 15-day notice because I'm subject to the local jurisdiction. So now we're in the month of February, and let's pretend that your local jurisdiction says that rent's deferred for 1 year. So now I can't do anything until February 1st, 2021. But you see, what the local jurisdiction didn't realize is, since they didn't have the right to serve the declaration, then that amount owed is not a civil debt. Or it could be a civil debt, but what it isn't, it still is rent. So on February 1st, March 1st, let's go back. February 1st, 2022, I could technically serve a 3-day notice to pay the rent and evict that tenant. So I guess some of the local mayors didn't understand that by taking it out of the state law, you're not transmuting the debt from rent to a civil debt, which means that in that 1 year, when that rent finally becomes owed, I can serve a 3-day notice for that rent. So it's kind of a curious thing on that.
They had 3088 on the brain when they made when they made the law and forgot to put those things in there, huh?
Yep.
I'm glad they forgot. All right. Lee in Pasadena. We have a tenant in Pasadena. We served a 60-day notice for a substantial renovation back in February. And obviously we had to allow them to stay. We still want them out. Can we start the process again on March 1st?
Okay, so what you're saying is they were served with a notice to quit in February of 2020?
Right.
Okay, you're going to need to serve another notice. That notice is void. So once you have the right to serve a notice to quit, you're going to need to wait till February. Now, if you're not subject to any local rent control ordinance or you're not subject to statewide rent control, then you can actually serve a 60-day notice now. The way the law is written, the Tenant Relief Act, but actually someone is pointing out to me that it really should be called the Tenant Welfare Act. That's another way to state it. I'm calling it a governmental assault on income property owners or a Tenant Welfare Act.
Yeah.
But you can actually serve that 60-day notice now without a reason, but you can't get a judgment prior to February 1st, 2021. So right now, if you serve it, the notice is going to expire approximately January 19th. You wouldn't be able to get a judgment in 11 days anyway. So if you're not subject to any rent control, you can serve your 60-day notices now.
And again, that was specifically for Pasadena. Not sure if you know what the
Pasadena is subject to LA County, so you can't do that.
Okay. Very good. And then on Facebook, we have Cecilia. What happens if a tenant is a problem tenant, not paying rent, the police have been called out, but no police report was provided?
Yes, I'm actually glad you raised that issue. One of the reasons which is not related to rent that you can also evict on is the tenant being a nuisance. So if the tenant's conduct rises to that of a nuisance, other tenants are complaining in the building, loud noises into the late evenings on many, many days, police being summoned to the premises or threats of violence, all those cases can be brought right now. Those require us to serve a 3-day notice to quit. And then bring forth an immediate eviction. So
Yeah.
those are good cases,
And-
assuming you have, a tenant that's off the deep end.
And here's even a more key piece. The tenant is in a guest home and the lease is expired on October 31st, 2020.
Well, again, if the lease expired and you're not subject to any local or state rent control, you can ask that tenant to vacate or bring forth an eviction. But if it's subject, then you're stuck.
Yeah, so City of Reseda.
Yeah, that's going to, well, if it's a permanent guest house, for example, and therefore it's not subject to statewide rent control because it's brand new, and it's not subject to Los Angeles rent stabilization, you still can't serve a notice. Why? Because the mayor in their Protection Act, eviction moratorium, the mayor for Los Angeles has stated there shall be no fault evictions. But you could serve, if the lease just expired, that one you could go forward with.
Okay. And Viking on YouTube, do you think they'll extend the date beyond January 31st?
And the answer is no, I don't think so. But ladies and gentlemen, you're not going to believe this. I've been wrong before.
And things that we believe would never happen, laws that we thought would never ever come to be a possibility are now the laws that we're under. So yeah, we never know. And does AB 3088 sunset in 2025?
It does sunset in 2025, but as to a lot of the protections, it's over as of February 1st.
Okay. And then Tina on YouTube. So if there's an eviction moratorium in our city, do we need to serve the 15-day notices?
Again, we've gone over this. The answer is you have to comply with your local jurisdiction.
Right. And David on YouTube, how long do you anticipate the courts will be backed up for the civil cases?
I mean, right now, I do see that for some of the civil cases, you've got a lot of pent-up emotions where, for example, cases dealing with personal injury, traffic cases, those are now being filed on rapid fire. So those cases can. The eviction courts seem to be open and doing okay. At least that's what we're finding now.
Great. And Trish on YouTube, my lease expired in May, but I was told by your office that I should continue collecting the rent since I couldn't evict the tenant.
And that's potentially true. If this is a rent-controlled unit, the fact that the lease expires means nothing. That lease might be over, but it's a month-to-month tenancy, and you would need to have good cause to evict.
Right, okay. And here on YouTube, does 3088 preclude a landlord from raising rent in a property that is not under rent control?
And the answer is, we've discussed that, and the answer is you are free to raise the rent.
Okay. All right. All right, we have Ray Young Chu on YouTube. How long does it take for an eviction if the tenant is in violation, like a nuisance, inoperable vehicle, unwilling to open the unit for maintenance? How long does it take for an eviction in that circumstance?
Well, those are all good reasons to evict, I might add. Again, we're quoting anywhere from 4 to 10 weeks, depending on what the tenant does, for an eviction to take place.
Okay, great. And if any one of those things happen, is it enough, or do you need to have a certain number of occurrences, or is there a
well, for example, inoperable vehicles, we would be serving a notice to perform or quit.
right?
And if they remove the vehicles within the 3 days, then the tenant has complied. So it really all depends.
Great. All right, on YouTube, what does sign under perjury mean?
It means very nothing. I know a president that was found guilty and nothing happened to him. So not the current president, I might add, but another one. But I think I'll drop that right there. But so you're right. So let's pretend the guy's never lost his job. Okay? I don't know why I'm picking on guys. It could be a girl. But the guy hasn't lost his job. And in fact, his boss during this pandemic has given him a bonus. And the guy signs this under the penalty of perjury because he would choose, to get that new car. So he signs something under the penalty of perjury saying he is affected by the pandemic and has an inability to pay the rent. Okay? So I just want to see which city attorney's office is going to bring forth a perjury conviction when it can be easily proven that the guy committed perjury by signing this declaration, because that's what it is. It's a criminal offense to sign a declaration under the penalty of perjury when something turns out to be untrue. But again, you might as well laugh your way to the court, because there is not going to be one conviction in the entire state of California based on this, that the tenant signed a declaration and it was untrue. Not one case ever.
Great. And Gerald on YouTube, I have a 3-unit where the tenant is not paying. Can I move my son in the unit, or does that only apply to a single family?
Well, again, if you're not subject to if you're subject to a local rent control ordinance, you'd have to follow that. If you're subject to the statewide rent control, that is a ground to evict that you could bring forth right now. Again, you'd have to pay relocation money, which is 1 month's rent.
Got it. Okay. And Carl, is email and acknowledgement back from tenant via email legally binding?
It depends what context and what document we're talking with. Most things under the law, emails, are not considered to be binding. Some things are. I would need to know the context and what documents you're referring to.
Okay. And can a tenant be evicted for not paying the utility bill to the landlord?
Under the Tenant Relief Act, Tenant Welfare Act, under that statute, any charge that's owed comes under the auspices of that act. So you'd have to serve a 15-day notice for any monetary obligation, including utility.
Okay. And Glenda is in LA. Is LA County moratorium restricting all unlawful detainers, including termination
No,
of tenancy?
if you're subject to the LA County moratorium, not the city, but LA County, you've got a curious situation there, that by mistake, LA County allowed their ordinance to lapse as of September 30th. So as of September 30th, we now jump into the Tenant Relief Act, AB 3088, what we've been referring to. So for rent owed for October and November, you can serve a 15-day notice if your property is subject to LA County. So let's pretend you're in an unincorporated area of LA County, or you're subject to a city that is now part of LA County. It doesn't have its own eviction moratorium rules. You can now serve the 15-day notice on the tenant. So you now just have to deal with the state law. You don't have to deal with the local jurisdiction. So LA County, by mistake, and they realized their mistake, could not extend their statute beyond September 30th.
Okay, and so the 15-day notices is not limited to rent only.
15-day notices are limited to
It's
rent
limited
only.
to rent only. And
Right. Otherwise, you'd be serving like a 3-day notice to perform or quit.
And can you serve for other unpaid amounts?
No, it would have to be still that 15-day notice,
Okay. And utilities too?
including utilities,
Yeah,
correct.
okay. There we go. Got that one done. David, do you have to serve the 15-day notice every month they are late?
Yes.
Yeah.
Yes, you do, because you want to have that declaration for each and every month. And I mean, logically speaking, if you truly lost your job, and let's pretend you lost your job in September and October, but you got your job back in November, well then technically you wouldn't be able to sign the declaration for November, but you would be able to sign it for September and October. So technically you should serve one for every month to commit your tenant to show that the tenant had an inability to pay for the specific time period in question. The interesting thing will be when the tenants go into court and try to indicate that they have this defense, that they had an inability to pay, the lengths that landlords are going to go to try to prove that the tenant is telling an untruth, that in fact they subpoena his employment records to see how much rent is,
Yeah.
how much
Yeah.
income he was actually making during this time period. But it's going to be a very big uphill battle for landlords who are probably not going to want to go through it.
Great. And what happens if you don't serve the notice?
If you don't serve the notice, then the tenant has no obligation to do anything. He doesn't have an obligation to pay. He doesn't have an obligation to sign the declaration.
I mean, every month, like every single month.
Well, then when you go forward, you're going to only be able to sue for that month that you did.
Okay. Okay. All right.
I mean, you can bring forth a civil lawsuit for all those months. That's always available to you.
Hey, Dennis, guess how many questions we have in the backlog?
Well, I can tell you that as I look at my watch, we've got about 10 minutes worth.
We have 77 questions in backlog.
Only
right now.
77?
That's it.
I feel like I'm doing like a presidential news report here.
Right. So everyone, there's no way we're going to get to all of these. And Dennis, you can please give him a call. He'd love to answer your questions. He has a full staff, and they have a nice setup where you can even just leave your phone number and you don't even have to wait online, and they'll get back to you when they're able to. So just remember that and give him a call. But here we'll answer a couple more. So we have Luisa, and she's on YouTube. I think there are some projection for additional occupants. Oh, protection. I think there is some protection for additional occupants due to the pandemic. I thought I saw that. So is there not a protection, or is there a protection for
There's nothing under the Tenant Relief Act, which really just deals with rent, but you might have a local moratorium that states that if the additional occupants are there and it's related to the pandemic, then they have the right to bring in those additional occupants. But really, what would that be? If the tenant has caught the pandemic and now needs other people to move in to take care of them, well, that would seem like it's related. But in most situations, they're just bringing in extra people, has nothing to do with your tenant. The same thing is true with pets. Well, I needed the pet, but again, it has nothing to do with the pandemic. So,
All right, here's Cynthia. She has one of those tenants. Can I evict a tenant who puts a chain lock on her door without approval? And then also they couldn't enter the unit when there was a leak, and that was coming from her unit, even though she was inside just looking at her, not letting her in.
that would be considered putting a chain link or a changing locks. That would be considered an alteration of the premises.
Mm-hmm.
Most rental agreements provide that you cannot alter the premises without the prior written consent of the landlord. So in that situation, we would immediately serve a 3-day notice to perform or quit. We would wait 3 days, and then we'd have to now serve a new 3-day notice to quit. I know it's crazy, ladies and gentlemen. And then we'd be able to proceed forward with the eviction. I do want to thank everybody who's attended this seminar. We're going to do another one next month.
Yeah.
What day are we doing it next month, ladies? Is it December
17th.
17th, so stay
Great.
tuned. You'll get stuff in your email or on the AOA USA website. Once again, my name is Dennis Block, in case you forgot. And our telephone number at the office is an easy one. It's 1-800-77-EVICT. That's EVICT.
Mm-hmm.
Or you can go to my website at evict123.com. Jeff, Dan, Apartment Owners Association, thank you very much for this opportunity to educate all the members.
Thank you so much, Dennis. And just to remind you guys, what you don't know may cost you a fortune. So what you've learned today hopefully will save you a fortune and save you a headache. And we do want to encourage you to join AOA. Just get on the website. You can join right there. And don't miss out. Make sure you subscribe to this AOA USA channel and hit that notification bell so that you get those notifications when they're coming. And also, you can do the same on YouTube. You can like us there. Like us on the Facebook here. Make sure you share it with people that you know. And on December 3rd, I want to remind you, Paul Reyes, he's going to come again, and he's going to tell you what you need to know about SB 721 and building inspections, that kind of stuff. So again, he was really informative a couple weeks ago with how to make sure you get a manufacturer's warranty covered on your roof. And then again, he'll come with some really good knowledge. You'll want to be there. And again, thank you for watching, and we'll see you next time.